Hello, my name is KENNETH VERCAMMEN. I'm an attorney from not that far away in Edison. I volunteered for South Plainfield in the past. Years ago, I volunteered filling as their prosecutor, so I'm not that far away. So typically, people want to know, oh, what do I need to know, or what's new? So, believe it or not, New Jersey did away with some of the taxes. They did away. Up to a few years ago, there used to be a New Jersey estate tax on every dollar that was going to people out other than the spouse over $675,000, which was a lot. New Jersey did away with it. Now there's still a federal estate tax, but that only applies to the people in the room that have more than $13,900,000. And if they had that much, they'd be like they'd be in Florida or a warm place now, looking over at the water, not hanging out here. Also, in a way, since COVID, things became easier to do because the old system used to be someone calls up the lawyer. Oh, I want to make an appointment to come in and do my will. So, okay, look at all the stuff, and two people had to take off of work, and even before COVID, we started emailing out the questionnaires because it made it easier. Now, some of my people didn't go to college. Some of my Elks Club members, and brethren, they goes, Penny, I'm not good with the computers. I goes, okay, no problem. It's a one-page form we email. What's your name? What's your address? Who's executive one? Who's executive two? Who'll get your stuff? So similar to sometimes your senior citizens. Oh, I'm not good with computers. I go, yes, but you have a child or a grandchild that is probably very good with computers, and so you say to them, especially when they live like 2 or 3 towns away, you don't see them often. Listen, do me. I need you to come over for 15 minutes and help me with something. I'm going to give you $5,000 to do it. Well, most of the time that child, that grandkid goes, great. Not to, and every once in a while, on the other hand, they'll say, oh, Grandma, I'm kind of busy. I'll say, you're too busy to see me for the next 4 weeks. You're okay, no problem, I won't leave you any. So, we've done programs with the surrogate's office in the past, and the surrogate is kind of the first one to say, when people have a valid will, properly signed, properly witnessed, it makes things so easy and in and out. Let's see. On the other hand, when there's no will, or the surrogate says when people like cheap out and try to do something themselves, then it becomes a problem. So the will can't be, if there's no will and not a medical probate, that means all the kids got to agree upon who's going to be the administrator. Some families say, oh, my kids all get along, they're good stuff. But it still means that the person who's not going to be the administrator has to sign this formal renunciation in front of a notary, pay a fee, and have it filed. And that's where people get along. Every once in a while, though, after mom, dad, or whoever passes, oh, can you sign? We need you to sign this. Oh no, I want to be the administrator. What? How can you be the administrator? You live in Tennessee and you don't got a computer. Oh well, I want to be the administrator. Well, then that means that there has to be thousands of dollars spent on a complaint board, a show clause, and a superior court to ask that someone in the family be appointed as an administrator. And every once in a while, the superior court judge says, you know what? You don't like that person, they don't like you, you don't get along, I'm going to appoint someone on the outside. It's going to cost all you guys money. Congratulations. Look what you've done. So nobody really says, when there's no will, a lot of times it causes more stress, problems amongst the family. So when loved ones are grieving, you want to make things easy for them. No one, we've never had someone after we did a will say the next week, oh, I wish I could do that. Everyone says, I'm glad I finally got that done. So, now, also, if there's no will or the will wasn't properly signed or prepared, that means that the administrator has to spend a couple grand more to take that thing called a bond, the surety bond. So, as long as the attorney prepares it, it has that magic words, no bond required, it's not required. So which is good, saves the family money. It's about saving money. No one came tonight to say, I want to learn how to cost me more money. And so importantly, think about the surrogate said, beware the problem with the cheap or free online things is it says valid anywhere, but it's like doing your own electrical work, she said. Let's say if you do your own electrical work, you save some money, but most likely you're not going to do it right. So let's think about if you don't have wills, who's executive one, who's executive two, who gets your stuff. It's as easy as that. So you got to think about so, and remember, it's your right to do with your assets what you want. If the only thing you can't do is leave a spouse penniless. But other than that, if you want to, leave, a higher percentage to someone or leave someone else, hey, that's your right. So, I'd say the form, it seems kind of scary when we send it to someone, but it goes, okay, your name, you have a spouse, where you live, who's executive one, who's executive two. We tell people never have joint executives because it creates twice as much work. That means that both people got to sign every check and do everything. They got to go to surrogates, they got to sign if there's a sale of the house, then go to closing, they got to sign everything. Why make things more complicated than things already are? The idea is making things easy. Because not too many people have more than $13 million, we don't ask any questions about what people's assets are. Don't need to know. People, I'm getting together my list of assets and the account numbers. He goes, I don't need any of that stuff. Who said, I thought you did. He goes, no, I don't want any personal stuff. I do ask what real estate you have in New Jersey, what real estate you have anywhere else in the world, and then an approximate amount of everything else. Pretty easy. I mean, it's kind of something you should know. I don't need a list because assets are not set forth in the will. Last week, Mr. S said, you didn't list any of my assets. And I go, well, I need you to email me the day you're going to pass away when you own that day. He goes, I don't know that. He goes, exactly. That's why typically most people say, hey, whatever I have, this is where it goes on my last day. And if you're lucky enough to spend it all, good for you. That's now we do. It is important though, before you email or talk to the attorney. Hey, who's getting your stuff? Ask your client says, do I have to treat all my kids equally? My 4 kids. He goes, no. What's your concern? He goes, well, my oldest son lives on the West Coast. We don't hear from him much. Well, okay. Did he call you or send you a card on Christmas, your birthday, or Mother's Day? She says, no. I goes, why would you leave anything to that bum? Because he's a bum, and the day you pass, he's going to be the first person yelling, where's my money? Where's my money? I'd say, won't go to the funeral, but where's my money? You don't leave a dollar, no reason, nothing to X, period. Now sometimes people, again, I mentioned you don't have to leave it equally to people, and some people, there's important reasons sometimes. Mrs. W had three daughters. I'd say she goes, I want 90% and the house to go to daughter number 3. I go, okay. I asked him. He goes, daughter number 1 is married to Dr. Rosenberg, the plastic surgeon. That's worth millions. And daughter number 2 also does okay. Daughter number 3, she was married to the bum that never paid child support and never worked, and it was a bum. She needs it more than I love her. She goes, I love all my daughters equally, but if the one daughter gets $200,000, she's going to go and goes, oh, I need another $200,000 piece of jewelry. Nobody needs, my wife found out that my son bought a $6,500 purse for his girlfriend. $6,000. So my wife and I were planning a trip, and I goes, hey, if we're going to Alaska, I want to go see polar bears. So I look into it, and it was $5,000. Why? Goes, you got to spend $5,000. I goes, what? We can't spend the $5,000, so my son inherits it, so he can buy another $6,000 purse. I'm going to see polar bears. I'm throwing them cupcakes. I want to be like Larry through the Three Stooges. He lived big, and died almost penniless. He goes, hey, that's great, because he enjoyed his life. Now, some people also have a child, a grandchild that wouldn't do smart things with money. They could have a substance abuse problem, they could have an alcohol problem, and one of the estates that I'm working with again, mom set it up. She goes, hey, listen, equally to my 4 kids, but the money to my oldest son goes into a testamentary trust to be administered by this one daughter because he's an alcoholic, and if you're an alcoholic, you get $100. You go to the liquor store, you buy $100 worth of stuff, and then you piss away the rest because instead the daughter could make sure his rent was paid, his car insurance was paid, other stuff. And so the guy's ex-wife, went to filed a complaint Superior Court saying, Judge, I want you to order the testamentary trust and the will and the trustee to pay me my alimony. I represent the estate. That goes, Judge, the whole reason for setting this up is to protect you from any creditors, period. And the case law is it's even protected from Medicaid, welfare, taxes. Mr. Vercammenen, can I see that? Hey, that's the law. That's why you do that. So some people say it was called testamentary trust. Other people say this. I got my kids already have a house, but I think instead I'm gonna have it for my grandkids to pay for their college in the future, which is smart because nobody really thinks much about how much college costs until you're getting closer to knocking on the door of taking the SATs. And I was kind of surprised how much the schools that my son was looking at. Because I was lucky because he worked hard and was smart in the head. We all say we're blessed that my son was a better athlete and got higher SAT scores than his father. So again, some people leave it to their grandkids. It's your right to do what you want. And if you want to leave everything to the Yellow Dog Society, you can. Yeah, sure.
About trusts?
Yeah. Well, if it's, I'll talk about trusts after I do the will stuff. How's that?
Okay.
So what I was just talking about, it's a testamentary trust within the will. So that means that you're not setting up, you're not changing how your assets are owned. It just sits there. And listen, if 20 years go by and it goes, okay, listen, they're grown or 10 years, they don't need to have a testamentary trust within the will, then that's just or usually when there's minor kids, we put in, they get nothing outright. They get some when they're 22, some when they're 25, the balance when they're 30, but as much money as is needed to pay for college, education, maintenance, support. So if the kid finishes college and says to trustee, it could be an aunt or another family member, hey, listen, I just finished college and I'd like to buy a condo in the town where I got a job. Trustee would say, okay, that makes sense. Person says, okay, listen, I finished college, I'm getting married, weddings aren't cheap. I want it nicer than the Knights of Columbus or the Elks Club. Okay, fine. On the other hand, kid drops out of college and says to trustee, hey, listen, college isn't for me right now. I need about $80,000 so me and some of my buddies can take a trip so I can find myself. Trustees can say, go get a job. It's this new thing, it's called get a job. So, now, the next thing we're going to talk about, what's called specific bequests. sometimes someone has, listen, I got, some of the ladies sometimes say, listen, I want my jewelry to go to, you know, girls in the family. Because you say, listen, if my son's the executive, he's going to bring the cash for gold, because what do you give me for this junk? You know my grandmother's engagement ring. What do you give me for this junk? You know, and you know, those are the scary things with these cash for golds, and you never know if they're telling you the truth about, this is, this diamond isn't worth that much, and yeah, at least with a coin you can look up online and see what the value is, but you can't really figure it out with a diamond. So, you know, so that's an idea of a specific request. Some people say, listen, I want to leave $5 grand a piece to each one of the grandkids, but they don't get it until they're 21. It can be used for college. Some people, you know, sometimes there's guys that say, I have my prized possession is my autographed Joe DiMaggio thing. It's worth a lot to me. I'd say, yeah, my daughter, the executive, throwing a garbage can with all the other stuff that is worth something. I'm going to give it to this, you know, someone. So, you know, so those are examples of specific requests. Sometimes people leave, you know, a set amount of money to their favorite charity, church, etc. We do put a clause in: if this item no longer exists, they don't get the money's worth. You know, but so, you know, I did say one lady, she had many kids, and she was talking about her jewelry and having it go to, you know, family members. She goes, I said, have you worn any of these pieces of jewelry in the past 4 years? And it was stuff worth money. It wasn't like, you know, she didn't buy it at the flea market, or, you know, what she got on the cruise ship. She goes, yeah. He goes, have you worn any of these in the past 4 years? No. Are you going to wear any in the past 2 years? Probably not. Or just give it to them now. I mean, they can enjoy it. I'd say, yeah, you know, I mean, you don't have to worry if your house is going to get, like, broken into. But this way they can enjoy it. And listen, you same thing with, like, you know, sometimes, you know, grandparents give it to their grandkids. It goes, hey, listen, most likely they're going to be wearing it the next time you see them, family events. Hey, look, I got this from, you know, thank you. So those are some ideas on specific requests. And I already mentioned the reverse specific request. I leave nothing to X. Okay? Now, you got to make sure in the will it sets forth if someone passes away, who gets their share. Don't leave it for question mark, because unfortunately if there's question mark, you know, someone wanted to have a will. I'll let my executor decide. No, you can't do that. What you have to do is you have to say, if this person passes, their share goes to X, you know, anyone else in the family. Because you don't want to have guessing and guessing. So now, I mentioned you know, who gets your assets, but everyone here has assets that would not pass under the will because you probably already have direct beneficiaries. So if a house is owned husband and wife, automatically goes to the surviving spouse. Okay? Will can't change that. I'd say if you have bank accounts that are payable upon death or joint, automatically goes to that person. Let's see, assets that pass by contract, IRA, 401k, life insurance, automatically goes to who's ever there. So some people have put a child on for convenience so they could access the account, but you know, just under law, they get. Having said that, you know, 2 weeks ago, a client when we're signing says, well, you know, I know my daughter's on the accounts, but she would do the right thing. I was, well, of course you do the right thing while you're alive. I mean, you know, on Easter Sunday when you're having dinner, she's not going to say, oh, by the way, after you go, I'm screwing all these other guys. They don't get nothing. And a lot of times people are influenced by whoever they're living with. So, you know, just something that you kind of think of. It is a good idea to get an old-fashioned printout of that page that has the beneficiary, and you fold it and you put it wherever you keep your will. It's just so it's helping the executive. So the executive doesn't have to figure stuff out. You know, but it is still a good idea to put down beneficiaries on these accounts, because that way they get it a couple weeks faster. You know, probate in New Jersey is easy. Say, the nice lady in the front, she asked me, wanted me to touch upon like trust. And every week, you know, we get a call by someone, and I'll touch upon it. Okay, so now, if you already have a will, look at it. First of all, you got to know where the original's at, because only the original will can be admitted to probate. Let's say it, you know, it's no longer, it's not in the lawyer's office, it's wherever you put it. And our rule of thumb is if you can't find it, quick, go and sign a new one. An original will is good forever until you pass, but it's got to be the original. Photocopy, no good. No. Now, sometimes you want to change who the executor is, not because you don't like that person, but they could no longer be able to do the job. Our rule of thumb, it kind of is, if someone is not, they should be able to drive and go to a bank. If someone is homebound or doesn't drive, you know, if you have someone else in the family that can do it, you know, we're often doing wills where, you know, it's still going equally to the kids, but when they did it 20 years ago, both people drove them, and, you know, we're working full time now. Neither of them drive, they're getting ready to go into either assisted living or somewhere else. Neither of them would be able to do the job as the executive. So, a couple of things to think about. We always have a clause that, mentions people under 21 don't get money outright because 19-year-olds don't do smart stuff with money. And maybe you people are more responsible than me, but if I would have got money. So, last thing I'll touch upon on wills is there's a change in the law that provides for what's called a self-proving will. Self-proving will. Prior to that change, that meant that the person signed and two witnesses, but then one of the two witnesses had to sign an affidavit or go to the surrogate's office to say, yeah, I was a witness and I watched him sign. Well, that a lot of times created problems because you couldn't find a witness, and the witnesses were dead. In my own family, my grandmother passed. We finally located the one witness because we've done it our own way. Witness lady goes, yeah, I can sign the paper. My fee's $500. It's $500. Not paying $500. That's more than the cost of the will. She goes, we'll get the other witness. Well, she's dead. So instead of going to court. So make sure that you have a self-proving will, and the surrogate, we do it, but the surrogate said, the cheap things they see online does not have the magic words self-proving will. So again, you want to kind of make sure that it's done right. Only executive 1 and executive 2. Some people that work have are covered through some legal plans through their employer that pays for the will. Some of the plans in New Jersey that are popular are the MetLife legal plan, our legal plan, and legal needs. If someone has a special needs child, it's a good idea to make sure they don't get the money outright because they lose their entitlements. Now, the last thing I'm going to say about wills, because really I only get about 35 minutes or so. If you don't have one document, get it done. Don't put it off. Everyone, I'll wait till the weather gets better, or I'll wait till I have time. You never have time. If they made every day 30 hours, you have all the time you need. But that can't be done. So don't be a Carl. What's a Carl? Carl was this retired engineer, and he wanted to have a will done. And these engineer types are the ones that always had to read and understand everything. When they used to get a new car, they would read the whole book. So I go to Carl, listen, I recommend this, and this. Well, I want to read up more up. Carl, you don't need to read anything. Listen, I went to law school, I passed the bar, I go to seminars, I wrote a book on this, I lectured. I've done the work, I want to read it. Carl, listen, when I had knee surgery, I read nothing about how they were going to do the knee surgery. I don't want to know. If the doctor says, I'm going to show you, I'm going to have a video of what I'm going to do, I go, I don't want to see it. That's going to gross me out. Doctor, just do the best you can on the knee. Carl wanted to read. 2 years later, Carl's daughter calls, and she says, do we have his original will? Because she found our business card and some of the brochures at that. at the house. He goes, no, he never did. I wanted to say, cheaped out, never did this stuff. Wanted to read. He wanted to go to the library and read 10 books on doing the will. So it cost him $1,000 more because he never did what he needed to do. A will properly done makes things easy. That's it. Probate in New Jersey is easy. All the surrogate really needs is the original will, death certificate, check for about $190, and you give him some information. You go, make an appointment. You go in. He goes, okay, here's your papers. Good luck to you. That's it. Now my mother-in-law used to call me up every other year. She's still around. She's 93 years old. And I want to come in and get a trust. I want to get a revocable trust. I go, we were watching Susan Orman on TV. And she says, smiles, oh yes, well, Susan Orman is right. If you live in New York, California, Florida, where probate takes 3 years plus 15 grand. But it doesn't cost that in New Jersey. Now, so whenever someone says to me, I want to get a trust done, it goes, why do you want to spend $6 grand or more setting up a revocable trust? I want to avoid probate. Okay, well, good. It's more money for me, but probate in New Jersey is easy and expensive. Revocable trust doesn't protect assets from nursing home or taxes. Some of the trust salespeople we used to have asked, oh, like avoid probate. Probate's the devil. It'll and a trust is secret. He goes, well, what do you care if people know? Once you're after you pass, the wills what do you care if people know? I mean, unless you're leaving it, your assets to bad people. What do you care? So anyone who says I want to get a revocable trust done, he goes, why do you want to spend all this money? I had a gentleman he was one of my neighbors. I explained that to him and wrote it down. He goes, I still want to put I got 3 houses I want to own by the trust, and that way it goes to my daughter. So okay, fine. I want to spend the money. Now, there's a different kind of trust. That's called an irrevocable trust, also called a Medicaid trust. That's to protect your assets if you have to go into a nursing home. But it's very, very strict. It has all your assets can't be owned by you. You got to be retitled in the name of the trust. It's one just signing a piece of paper that says I have a trust. You don't own it anymore. You're not the trustee. And then there's a 5-year look-back period. Now, who pays for nursing home in New Jersey? Either yourself or welfare, because Medicaid is administered by Board of Social Services for the purpose of nursing. That's welfare. Someone asked me, well, it was a daughter had mom come in. Mom wants to do a new will, and the daughter starts, oh, mom wants to protect your assets. I could smell. Daughter wanted to try to protect your inheritance. Not mom. Mom didn't care. Okay. Well, I go to the daughter. Why do you take out long-term care insurance policy held by your mom? Well, I don't want to spend my money. Okay. And the daughter goes, what did you do? I goes, me? Let's see. Well, Medicaid only pays if you're almost penniless. I mean, if you have a spouse, they can stay in the house and keep some of the assets. That's okay. But if I go, me? I go, tell the lady, I don't want to go into the most expensive nursing home that exists. That's me. Because if I'm so sick that I can't stand up and brush my teeth and feed myself, I wanted to go in a better place, not the crappiest place. And there's some nicer nursing homes, and there's some ones that you'd be embarrassed if someone knew that you were there. He goes, listen. He goes, who worked for the money? Let's say I worked I always worked. Fast food, cooking like fries and cleaning the bathrooms in the fast food places for some of my more glamorous jobs. Jeez, I was a paper boy, delivering newspapers in the rain, in the winter. So I didn't have no knock on doors and collect like quarters and nickels, so I could make some money, so I could have my family was from South Edison. They weren't from the North Edison section. So I go, if there's any money left over, yeah, it goes to my 2 kids. But again, why should I go into the Edison nursing home so my son, Dr. Brendan, can have a fancier boat? He already has a boat. You know, I want a piece of chocolate on the pillow. I'd say, yeah. Now, again, he goes, well, I'm sure my kids would take care of me. He goes, yeah, well, again, while you're well, but a lot of times they marry someone and they start looking at the money. And so that's my little bit upon trust. I mentioned if anyone fills out that form, we do a free consult. Okay, now, let's talk about powers of attorney. Powers of attorney. Powers of attorney.
Wait, do I get to ask my question
Yeah,
about trust?
yeah, trust.
So you mentioned that it can be protected from taxes and nursing homes.
Okay, so to do what's called the irrevocable trust, the attorneys that do that charge between $13,000 and $15,000 up front. That's a flat fee. If you don't want to spend that kind of money, then that's the decision. It's a very specialized thing. It means you don't own it anymore. Now, I had someone say, I want to protect my assets in case I have to go to nursing home. And I looked at who their beneficiaries are, and it wasn't even kids, it was like nieces and nephews. I go, what the hell do you care? I mean, eventually they'll get the money, but why do you want to suffer? I'd say, here, does that,
No.
so what,
My
I don't
question
understand the question.
Yeah, right. I didn't finish.
Yeah.
My question is, can the state change the laws on the trust?
Yeah,
No?
yeah, they can.
They can.
So, originally, when I was first as a young lawyer, it was a 3-year look back. Okay? Then they changed it to a 5-year look back. Okay? Could they change it to a 6-year look back? They can. Now, ex post facto law doesn't only applies to criminal, so they could change it. But I'd say again, it's where kind of where you. I have to think of not the kids when people talk to me, but the person who signed the document. Everyone wants their kids to have money, but that's it. Who remembers before there were cell phones? Everyone, right? So how are we able to do stuff and function? So my grandmother lived to almost 105, and she was in her own apartment until the late 90s, and then like a kid knocked her down while she, bicycling on the sidewalk. She broke her head. She had to go into the nursing home. And so before cell phones, like I said, I was down in Ocean County, Freehold Lake area. So I said to my wife, "Hey, listen, I'm doing this 10-mile race in Freehold, and one of my buddies here to drop me off at the nursing home so I can see my grandmother." I goes, why don't you bring the kids down? They can see their grandmother while she's kind of still smiling and talking. And she goes, okay. Write down the address, Fountain View, 1611 Route 9 South, Lakewood, New Jersey. Okay. Okay. So also we don't have any GPSs or Magellan, so she's driving down Route 9. Sees sign for the nursing home. She goes in. She says, "This place is like dismal. There's some of these crappy motels that you see on the side of the road." Then she goes and she says, "Oh, this place is hard. It smells." And then she goes to the front desk. "Oh, I'm here to see Virginia Vercammenen." Someone barely looks up. "Not here." "Oh my God, they lost Ken's grandmother." This night, just 2 years ago, she was cooking spaghetti for us. She goes, no, I'm here, Virginia Vercammenen, Fountain View, 1611 people. Goes, oh, no. This is Smelly View. That's 2 miles down the road, because she was pulled into the first nursing home she saw, because she was supposed to be paying attention, not reading while you're trying. So, again, let's see. I ask people, why do you think you need to have a trust? I want to protect my assets. Okay, listen, if someone wants to do it, I got colleagues that charge people to do it. But the whole thing is, you can spend all that money, and then if 4 years go by, you got to go into a nursing home, doesn't protect anything. And see, if you pass away 2 years later, okay, well, you spent that money. Okay, I got to speed up. Well, power of attorney. The will takes care of your assets if you pass away. What the power of attorney is you're giving the power to someone to be able to act on your behalf while you're alive. For a lot of people, it's more important than the will, because listen, if you die without a will, there's a statute that says who gets your stuff. If you don't have a power of attorney, nobody can act unless they go through this. If you don't have a power of attorney, this expensive, complicated guardianship procedure. Power of attorney is pretty easy. Basically, it says, I'm giving the power to whomever to act on my behalf. If it's either effective right away or only upon disability. When it's effective right away, that's called a durable power of attorney. Stays in effect even if someone becomes disabled. If it's effective only upon disability, it's called the spring power of attorney. It only springs into effect if someone becomes disabled. So, last year, client Freddie's, we signed the documents. He goes, Kenny, I don't understand this stuff. He goes, I'm a carpenter. I don't understand the law. He goes, explain to me in carpenter language this power of attorney. I said, okay. He goes, the durable thing I mentioned, you put your son as your agent. Well, that means that he can steal all your money right away and then go to Cuba where there's no extradition treaty. If it's effective only upon disability, he needs a note from a doctor before he steals all your money. Knowing that, you trust your son? He goes, I trust my son my life. I goes, good. There's an X here. Sign where the blue X says takes effect right away. Yeah. A will I mentioned is good forever. Forever. It could be done on parchment. But there's no statute on power of attorney. So our rule of thumb is you should sign a new one every 5 years so the banks don't give you a hard time. Or if your address changes, if you die. Now, some of the banks, perfectly good power of attorney done last year, they would give people a hard time. Oh, it wasn't done in our first finality form, Wally. Well, okay, so New Jersey legislature came out with a statute saying if it mentions the New Jersey statute, then they got to honor it. But it has to mention Section 2 of PL 1991 C95 C 46:2B-11, and we pretty much know that the survey said the free things online don't happen. We revise our documents every other year to improve them, because sometimes it's new statute. So we added a HIPAA clause in, so people can legally talk to the doctors. We added a what's called to make decisions under the Pulse Act. There's now a designated caregiver in case someone has to go into nursing. So we put, even though that's more medical, we threw it to the power of attorney in. Last document I'm going to talk about. The Living Will Advance Directive. Living Will Advance Directive. Thank you. What the Living Will Advance Directive is. The will takes care of your assets if you pass away. Power of attorney gives the Living Will Advance Directive is you're giving instructions to hospitals and doctors saying, if I can't talk, this is what I want. And most people, I don't want to be on feeding tubes, I don't want to be on respirators. If the doctors say, there is no hope for me, I'm not gonna regain consciousness, and it's the end. And really, the document is not for you, it's for the people you care about, so they don't have to suffer and try to make that decision. You know, I remember some years ago, there was a little lady who lived in North Plainfield. I was her, because she didn't have children or spouse, so I was her executive of her estate, but and power of attorney. But she didn't want to sign a living will. I creeped out. Great, okay. You know, so then again, I get a call one day from the doctor. Listen, you're the power of attorney. So and so is in the hospital. She's like, she's not conscious and she's not coming out. Do you want us? And the doctor, do you want us to remove life support? I said, geez, I feel bad. He goes, you know the right call is for someone who's 92 years old. It's not going to open up their eyes again and enjoy life, but you hate to be the one to make the cost. Geez, I wish you would have did it. I couldn't even do it on my first dog. I said to my wife, listen, you got to do it. Even though we spent $16,000 on whatever focus treatment the animal hospital said, we got the next dog that goes, listen, we're gonna love you just as much. I spent $16,000 on you, for the never had it. So, with a living will, man, it's direct. 95% of people hey, if there's no hope for me, I don't want to have fluids and nutrition to be done. That's it. I don't want feeding tubes. I don't want extraordinary kit. I want to do not resuscitate, etc. Now, here's two other important things. Kind of changes in the law. It is a good idea to have someone that you trust to be able to talk to doctors. So the will has a person you're executive number one, executive number two. Your power of attorney is agent one, agent two for the money. In your living will, you want to have a clause, medical agent one, medical agent two. That's that way. There's one person who's the captain of the ship. Because also sometimes we find in families that there was one kid that was always the helpful one. And, making sure that mom or dad had their meds and someone was there, etc. And someone, on the other hand, that wasn't around much. But what we were finding was sometimes there was a person who wasn't around much when the person was on the last, days or weeks. Would come into the room and goes, okay, listen, I'm in charge now. Somebody do it old. I'm in charge now. This is what we're going to do. And the answer is no. You ain't in charge because the living will says this person's in charge, and we're lucky. You're lucky we even let you into the room. So that is the living will. I went over my time because I'm only supposed to go about 40 minutes, but. Especially important on having these documents is people who are not married. It's easy when someone's married because even though there's law, first of all, the law says the spouse gets the assets unless there's prior children from prior relationship. But I would say if people are not married, you want to pick someone, and even before they legalized same-sex marriages, we were doing them because what was sometimes happening was someone could have been in a relationship with someone for a decade, but they were never married, and all of a sudden the one person's in the hospital, and it's the end. And the family could legally say, get the hell out of the room. What do you get that? This is my partner. We've been together for 10 years. He goes, get lost. You ain't family, get lost. So, but if there's those kind of documents, you should have. So, with that, what I'm going to do is I'm going to go into the back of the room and answer some people's questions.